now. And I have to tell you, before the panel has even started, we've already had our first debate and discussion. It was about the title of the panel, and we had a spirited debate about whether it's the role of lex situs or the role of lex situs. And we'll let the group decide just how much lawyers will mangle the Latin language by listening to our speakers. We've got three exceptionally qualified speakers, and as a result, we chose a neutral principle for the order in which they will speak, which is alphabetical order. I know that's not truly neutral, but it's as neutral as we could get. Our three speakers, first of all, are Judge Alan Gropper, bankruptcy judge from the Southern District of New York, where he's served now for about 13 years. Before that, he was a member of White and Case, where he has extensive experience in complex domestic and international insolvency and restructuring, member of the National Bankruptcy Conference, a fellow of the American College of Bankruptcy, a participant in the work of Working Group 5. I'd say he's a well-qualified person to speak with us today. The second person I'll introduce is Professor John Pato, and you have his biography before you. You can just get a flavor of his qualifications by reading some of the adjectives and adverbs near the beginning. He's internationally recognized for his award-winning scholarship. Well, I guess that tells us quite a bit already, plus the fact that he's managed to be a clerk in the courts of two different nations, which is quite impressive as it is. And finally, the third speaker, actually the second speaker, but the third one to be introduced, is someone of whom I think you are quite well aware already. It is our host, Ted Janger. Ted is eminently well qualified, as you all know, but his most important qualification is he's been a wonderful colleague of mine for the last 15 years. He is someone who tells me I'm wrong when I'm wrong, and he's such a nice person that sometimes he tells me I'm right when
you're
wrong.
not wrong, right?
So I get both sides, and I learn from him every day. So now we all get to as well. So let's, without further ado, turn to this panel. And Judge Gropper, you're our first speaker.
I am delighted to be here in part because I'm among people, many from academia, who will tell me I'm wrong. Very few people in court tell me that to my face. I don't know what they say otherwise, but certainly I have had some comments as to my work. The question of situs or situs is one that I avoid, and on principle, in that if you want to get something that is going to fly in Oklahoma, I would avoid all Latin. And and I think if you want to get, you being the international community that has spent many years drafting the statute, if you want to get a construction of the statute that is more in accord with the universalist ideals of the statute, it seems to me that it is helpful to speak the language of the common law judges, at least in the United States, and they're the only ones I can talk about, and convince them that on a rational and traditional choice of law analysis, we ought to apply the law of the, forgive the expression, lex fori concursus, pardon me, and that it works under traditional U.S. principles. And frankly, I think that would help a great deal in achieving what I think is a reasonable goal, and that is a universalist system. As it stands, 8 years have passed since we adopted the model law in the United States. We have a number of cases, and not one, as far as I can tell, really discusses the issue of choice of law. Does that mean it's disappeared altogether? Not really, because every Chapter 15 case is implicitly a case that presents a choice of law issue. It may not present a conflict of law issue, but it raises the issue, should we apply the law of the situs, or the place where the property is located, i.e., let us assume the United States, or should we apply the law of the forum where the main proceeding is pending? Now, one reason why choice of law has disappeared is that it's not in the statute, but that isn't a good enough explanation. Many choice of law issues, particularly in the common law, are not statutory at all. They are the basis. They're based on principles that have been developed over many years. So I think the principles are there, but they've gone underground, if you will, and they come up in some of the exceptions to the application of law of the main proceeding in terms, and this I'm repeating what I said a few minutes ago before lunch, in terms like sufficient protection, which is the United States version of adequate protection, is found in Articles 21 and 22 of the model law, sections 1521 and 1522 of Chapter 15. And in our our section 1507, which is a much more detailed version of the very simple Article 7 in the model law. Now, I mentioned traditional choice of law principles. I recognize that many in this room, or many around this table, sincerely believe these to be a dismal swamp in which judges are able to exercise much too much discretion. I was quoting the heading from Jenny's article, but I'm not attributing that heading to her, but it's also found, I think, in the global rules. I suggest that these rules or these principles are more useful in terms of trying to establish a workable international statute than completely unknown principles such as adequate protection or sufficient protection. What are they supposed to mean when applied by a judge in the United States? We now have a leading case, Comonda, which many of you are familiar with, that asks the court to sort of balance the interests of the foreign against the domestic, and in that case found that the bankruptcy court had not badly exercised discretion in favor of the domestic. I think we would be on firmer ground if we looked on the question in that case as to whether or not we should apply German law or we should apply U.S. law to the question of the powers of the liquidator to reject the contracts. And if you did a choice of law analysis, I think you might be much more ready to apply German law than to say that, well, the American holders of the patents in Comonda are sufficiently protected by application of German law. And if you look on the question of sufficient protection, which is our word, or adequate protection, you, I think, are very much at sea. You're certainly trying to construe a new term, and a term that can easily be construed in favor of the home team and against the foreign applicant. There is a reliance question, and to use Leif Clark's analysis, and I think you can find the reliance issues in a fair choice of law analysis. Now, we're not totally at sea, let me emphasize, on the question of choice of law in insolvency issues. We've had today reference to the seminal case, some people say, in re Maxwell Communication Corp., which some of us remember directly. There, Judge Brosman said, the traditional federal choice of law rule is to apply the law of the jurisdiction having the greatest interest in the controversy. The court is required to evaluate all of the various contacts each jurisdiction has with the controversy in terms of their relative importance with respect to a particular issue, and make a reasoned determination as to which jurisdictions' laws and policies are implicated to the greatest extent. I submit that although this is a potentially broad analysis and one that gives the court some discretion, it's no broader than the question of what in the world the term sufficient protection means. And that if we looked at the issues as issues relating to a choice of law, is it appropriate under these traditional principles to apply German law to the powers of a liquidator, or is it proper to apply American law? I think that one would more readily accept the proposition that German law ought to be applied, rather than when we get into the vague term of sufficient protection and the issue is phrased in terms of them versus us. There are many other cases in the United States that apply a similar choice of law analysis. Frankly, this is the kind of choice of law analysis that I think judges in Oklahoma would understand, would appreciate, and would follow. I use Oklahoma, I have to say, not merely because Professor Mooney told me that he comes from Oklahoma, and because I have a warm spot in my heart for Oklahoma, for other reasons that I will not describe. But because another case that I use as an example in my paper is a case called In Re Civic, a case in Oklahoma when the issue was whether or not U.S. creditors holding a retainage escrow in Oklahoma under U.S. law could set that off against an Italian debtor's claim against them. If the Italian debtor was able to resist the set-off, they would win. And my understanding is that under most civil law rules, or the laws of most civil law nations, set-off is not recognized. It's viewed as a preference that should not be countenanced. I don't know what the law is in Italy. It was obscure in this case, and the case was totally mismanaged by the Italian Chapter 15 applicants. They failed to give notice to the U.S. creditor. They failed to make clear exactly what the Italian proceeding was all about. They failed to make clear that the U.S. creditor would have a claim in the Italian proceeding. They sent over some request for comedy that somebody wrote in somebody's office and got someone to sign. That's what the U.S. judge found. They did everything wrong to convince a judge in Oklahoma that this proceeding would give the U.S. creditor a fair shake. But when you come down to the real issues, it seems to me that the issue was, should you allow the U.S. senators, assuming Italian law to be different, and assuming there to be a conflict of law, which was not at all clear, should you apply the Italian law on set-off, or should you, the civil law on set-off, or should you apply U.S. law, which would recognize the set-off, and the Italian estate would get nothing? Actually, the global principles have got a rule. I think, as I look on the facts, I think if you applied the global principles, you would allow the set-off because U.S. law would apply. If you apply the legislative guide, well, everything goes in favor of the lex fori concursus, Frankly, I don't think that is a principle that would succeed in most U.S. cases. I think it needs to be refined significantly, but that perhaps is for another day. But I think that if you start an effort to make a serious and sophisticated and fair choice of law analysis using principles that we've used in the common law, at least in the United States, for many years, I think you'd get a better result, a more universalist result, if I can use a term that I do not use in my paper, and a result that is more satisfactory. The same is true with regard to the exceptions to granting additional relief that are found in the U.S. version of Article 7, Section 1507. Those, as you know, are the old Section 304 principles with comity elevated. Those principles have been criticized as giving courts much too much discretion to deny recognition and effect to foreign legislatures, to foreign representatives, but they are there. And it's very hard to reconcile Article 7 as adopted in the United States with Articles 21 and 22. In the Vitro case, which Jay and I both discussed very briefly before lunch, I think Judge King made a heroic effort to analyze where Section 1507 starts and 1521 leaves off. But assuming that the analysis was correct, I think we would be much better off if we introduced a conflict of law analysis in accordance with the old principles, as diffuse as they may be than we are under the statute as it's written today. One other area in which I think conflict of law principles could be very helpful is when you have an actual conflict between courts. And the example I use in my paper is the very well-known case. Its author is here, Judge Peck, in Lehman Brothers Special Financing against BNY Corporate Trustee Services, where we had decisions of the English court going up to the English Supreme Court, holding that under English law it was perfectly appropriate to change the order of, or the rights in certain collateral. Judge Peck found that under U.S. law this was a improper ipso facto clause that was invalid. All right, we have the two conflicting decisions. How do we resolve them? I think we resolve, Judge Peck said that there should be further proceedings. We should respect each other, and we did, which is all fine as far as it goes. How do you resolve that issue? I suggest you resolve it by conflict of law principles. Which state's law should be applied under the circumstances? Should it be the law of the place where the collateral was held, where the law that governed the instruments involved, or another law? I don't mean to suggest any result here, but I do think that conflict of law principles that are well developed could resolve even these issues and would help to make the concept of cooperation a reality. Thank you.
Not only a thoughtful talk, but you gave us two extra minutes with which to work. And Ted, I bet you're capable of using those 2 minutes.
I didn't give them to Ted.
No, I'll see if I can.
No, they get pooled up to the Comey estate for everyone else. So share the 2 minutes.
This is conflict of clock.
Those 2 minutes will be centrally administered.
Right.
Okay, so I think we did this alphabetically, but I think my paper follows naturally from Judge Gropper's in that what I think we're both exploring is ways in which choice of law can, if used properly, assist in the process of developing a coordinated and cooperative architecture for administering cross-border cases. Indeed, what I'm going to suggest is, or what I'm going to try to articulate in this talk, is a way in which choice of law can be used actually as a limiting principle to territorialism rather than as a default, rather than a decline into territorialism. And I'll put the takeaway right up on the table, which is what I'm striving for is the ability to articulate and calculate a global best interests principle based on a hypothetical territorial distribution based on not entitlements in the sky, but what a territorial distribution would look like in practice if a holdout were to say, fine, we're not cooperating, we're taking our territorial remedy. Once you've established what that amount is, you've got the ability to distinguish what we could characterize as best interests entitlement from, or territorial entitlement, or to use the terms that Jay and John will use, the reliance interest, right? We quantify it in a way that defines the scope of what's up for grabs for negotiation. And I'll get to my slides eventually. I'm going to suggest that once you've characterized it this way, a lot of the stuff that we're fighting about drops out. Because the only places where these cases are going to matter, or where you're going to be able to obtain a coordinated administration, a rescue, or a going concern sale, are ones where the rent or the value associated with coordinated administration is going to be substantial. And in those instances, the difference between whether we presume this or presume that are ultimately going to wash out and be and to the extent that we can do that, we take those disputes out of and de-stress the cross-border coordination architecture. So that's sort of the grand design. Now let's see if I can pull it off, right? So why do I think that this is the right time or the right thing to be thinking about? Well, let's look at for a moment where we are. We have current instruments, right, which are a tremendous advance, an unbelievable advance over what existed 20 years ago. We have the model law and the EU reg, which create an architecture, a procedural architecture for cross-border recognition, communication, and establish norms of, but not standards for, deference. And then we have the legislative guide, which gives a template for nations to modernize and update their bankruptcy law. The model law and the EU reg, except to the extent that they define lex fori concursus, don't really deal with choice of law issues. Neither does the legislative guide deal. Except for we'll talk about recommendations 30 to 34, but it does. Aside from again defining lex forum concursus, it doesn't deal with either cross-border issues or detailed choice of law principles. Okay. The basic notion here, which I think is an advance, is that the ancillary courts should cooperate with the main, and the main must administer the case or direct the case. And to the extent that there are choice of law inquiries embedded in all of those, they're black boxed, right? Indeed, the current approach black boxes them when I say black boxes them, basically says that the forum, either the ancillary or the main, will apply its own law, right? Article 4 of the EU reg, subject to exceptions, says that the court in the jurisdiction of opening shall apply its own bankruptcy law in toto, and recommendations 30 to 34 of the EU reg say basically the same thing, subject to exceptions for labor law and financial contracts. And I think recommendation 34 sort of sets the tone when it says you can do some other stuff, but don't do very many, and make sure they're clearly specified, right? Basically, it's a broad view of lex forum concursus, and this was, the idea was, and again, the right idea was to find ways to make sure that the main can actually administer the case so that we can achieve a coordinated governance. Okay, so why? Well, this goes back to Jay's early articles. Why would anyone cooperate? And the justifications articulated in the classic universalist vision are ones that an economist would describe as Kaldor-Hicks rationales, right? Rough wash, in the end, across many transactions, the gain to the world will be that we'll have more efficient allocation of assets, and in the particular transactions, there will be gain without really paying attention to how that affects individual claimants. And it makes sense and it's odd, by the way, to me, to find folks like, well, me and Jay and John arguing from Kaldor-Hicks efficiency. That's not our usual stance. And the problem is that at a certain level, the cooperation falls apart as soon as the stakes become significant. Once the outcome differences become significant, 365N, that's Lubrizol was the mother of all wrong executory contract decisions in the U.S. How could Germany think that that's a good idea, right? Trico, what? We prime the secured creditor? And now, they're all driven by this idea of shock, right, which comes from, and which then gets played into by this idea of sufficient protection. But they don't ask the question, well, whose law should be governing this, right? Are we talking about U.S. trademark or U.S. copyrights or licenses in Qimonda, or are we talking about licenses of many people with a German licensor? I actually don't know what the right answer to it is, but the court doesn't even talk about it. And for what it's worth, as Judge Gropper points out, increasingly the balance seems to be tipping in favor of local creditor expectations, which means that on some level this idea of sufficient protection is backfiring on us. So there's an emerging conceptual solution which John and I have been grappling towards from sort of opposite ends of the spectrum of what I just called a hypothetical territorial liquidation concept. And right now I'm limiting myself to questions of priority and distribution. Choice of law comes into play for other things, but, well, I only have 20 minutes, and I don't know the answer on the other ones. I know, I've only got, what do I have? I've got some. 12. Yeah, that's good. I can do this. We've got different names for it, and the terminology is getting a little bit hairy, right? From the choice of law perspective, I call it virtual territoriality. John has coined the term synthetic secondary, which has really sort of taken off within the international law discussions. I'll maybe take a second to explain why I don't like it. I like the concept, but the term has some freight with it. And then another one, which I came up with in another article, basically using a comedy approach, which is to say reciprocal comity, which is to say that the main needs to pay attention to what would be going on or what would be happening in the ancillary. So we've always been focused in all of this inquiry in getting the ancillaries to cooperate with the main. And what I'm suggesting here is a focus where the main takes into account what would have happened had a territorial case been opened. Now it's catching on. Gabriel Moss was modest when he mentioned that he'd been involved in 2 cases. Collins and Aikman and M.G. Rover were the templates, I think, for this approach of the as-if distribution described by Bob. And it's I've heard it referred to as the English approach, not the Moss approach. But it's and by the way, he first talked about it as an approach here. In here. Okay. So we laying claim to the intellectual property here. So credit where credit is due, and it's taken off. Right, the proposed amendments to the EU reg that Bob showed might not actually work exactly unless you do it Gabriel's way, right, is an attempt, I think, to validate that approach. And I've written elsewhere that I think normatively it's the right approach, but that's not why my question here today is whether one can actually do this thing. It's also shown up in current uncitral action items, as Chris pointed out, as having some possibility of being helpful in the discussions on corporate groups and the obligations of officers and directors. By the way, those are supposed to be silos. I don't know if that works or not. Okay. So that's the idea. Can you, in order to figure out what to do in the as-if distribution, can you calculate a hypothetical territorial distribution? Well, what does that mean? What you have to ask is, what would have happened if a territorial case had been opened, local assets had been liquidated, and were distributed to those who could assert claims in that case according to local distributional rules? And I want to be very clear when I say distribute to those who could assert. You want to basically be saying, what would the realization have actually been? Not to what extent might they have had a veto over some other things because of their formal rights. Okay? So in order to do this in any meaningful way, in order to figure out what the territorial expectation is, you have to do something that's kind of hard, right? And that Jay has yelled at me and said you can't possibly do, which is to locate the claims and locate the assets for the purposes of figuring out what the expectation would be. And so this, to the extent that we're thinking about using this approach, one doesn't need to harmonize choice of law rules. It just makes it easier, right? But could you do it? Could you articulate coherent choice of law rules in this context only for locating assets and claims? And it turns out, and I'm going to talk about another contribution of Bob's, you can take credit for it, which is the ALI III Global Principles for Choice of Law. There is an existing instrument that takes a stab at doing this. And I'm not going to opine on whether any of the individual rules are right, but I'm going to take a second to just show you can, right? And if you can, then how much easier this would be. So I didn't cite the particular rules, but these are my reading of the ALI III principles as to how you would locate it. And as I say them, you're going to say, yeah, that seems right. Real property? Hard to locate, right? No. Dirt's located where dirt's located, right? Tangible movable property? It's where located. Unless it's in transit, in which case it's located where it's going. Or unless it was recently moved, in which case it's located where it was. If it's registered, well, that's easy. It's located where it's registered. Intangibles? They punted. I guess they're hard. What about locating claims? Well, they do have some rules for locating intangibles. They have a rule for locating copyrights and specific types of intangibles. But let's just say that would be a tough project for the project. What about locating claims? Mostly you choose the location of the debtor rule, which makes sense for debt claims, right? Putting Pache Marquette, the Marquette case, right? And for all the reasons that the Marquette case is wrong in the U.S., the location of the debtor rule is right. But you probably have to unpack that a little bit when you're talking about non-debt contracts, which may have other contacts and other purposes. But there is real actual choice of law out there for doing it. This puts aside the question. Now, once you've done that, you can kind of do a calculation. Close enough. Does it have to be perfect? No. It needs to be so that Gabriel can say, this is what we can offer you, or can say, we'll offer you a range of this, And they'll say, okay, well, it's not worth fighting over at that point. And it only has to be close enough for the lawyers to work with, not perfect. And we still have a problem, which is how do you deal with bankruptcy treatment of those claims once they've been located? And with a secured claim, it's probably going to depend on the location of the asset, at least under my approach, right? What would happen in bankruptcy if they went bankrupt there? The priority of the claim is going to depend on where was the employee, right? Where was the tax claim? If it is entitled to. And pari passu claims turn out to be easy, right? You don't need to locate them. Because if you assume that everyone's going to be able to prove in multiple cases, central administration looks exactly like decentralized administration with a hodgepodge, right? You come out in the same place at the end of the day. So what is this, and what does it tell us for corporate groups? It makes things simple. You respect the corporate form, you respect local distributional priorities, unless, and this is where John and I are going to end up differing, which is I assume respect of the corporate form, unless there's no expectation.
Right.
And you would assume no expectation unless you can prove it up. I will submit that that's all we're fighting about right now, right? And so if we're down to that, I mean, I think John and I can hammer it out over a beer tonight. Because in practice, I think that most of the time, we'll be able, in individual cases, to actually agree. How am I on time? 4. Oh, my goodness. I've already so I get to the normative, right? Why bother, right? If we can do this, we can cabin territorialism, not just as a legal matter, but as a practical matter, right? The court in the main can say this is what we have to give these guys, and if you're giving them more because you agreed to it, so what? You can say, the lawyers who are here, make my day. Open a territorial district case. This is what you'll get. 10. We're paying 20 to everybody into the pari passu claims in the centralized case. And so why would you bother? Now, that does raise the question. So what it does is it allows us to distinguish the value of the collateral, in other words, what your actual value of the collateral is, from what we'll call I would call bankruptcy created value, or here what you would call the value of central administration or coordinated administration, which is going to be the subject of negotiation no matter what we do. But to the extent that you can get rid of entitlements, then you can work stuff out. So how does it help? It enhances it has the potential to enhance cooperation by reducing the size of outcome differences, or at least quantifying them. To the extent that we're talking about, and this is a little bit of a topic for an entirely different, why does this matter for corporate groups? Imagine that you've got a centrally administered group, and you've got a territorial sub that says, I've got a wrongful trading obligation, or I've got or I need to know whether I should listen to the instructions from the parent. If the answer is, I need to listen to the instructions from the parent because this is all we'd get if we filed here, well, then you've got a basis for not filing or for figuring out what the distribution is. Now, the other thing that I care about and why I like this better than straight up universalism is that this also carries with it a respect for the dignity of national policy choices about loss allocation and mutes at least the sovereignty objection to the cross-border case by not starting with a presumption of we're wiping away everything that you've got nationally. Last point. Can we handle grand design, right? Can it be brought down to a couple of key action items that can be handled by international organizations? I think that 2 small additions to the model law and to the legislative guide, and by small I don't necessarily mean easy, right? To the model law, you might add a provision or simply a paragraph to the enactment guide that said the ancillary that empowers or acknowledges the existence of choice of law inquiries within the jurisdictional determination about when and whether to defer. And to the extent that we added something to the legislative guide, you might add a Part B to Recommendation 34 called Cross-Border Issues that simply allowed, and this is the key thing, allowed the court in the main to derogate from its national priority rules where necessary to effectuate the case. That was off-the-cuff drafting. And then to the extent that we talk about the general point, because this will put pressure on locating claims and assets, a principles project or other sort of ongoing effort that could be at UNCITRAL or elsewhere to at least get the conversation going towards a harmonized set of choice of law rules. And I am out of time. Thank you.
I did.
They locked me in. A stander, okay.
I'm peripatetic. Yes. I'm going to speak from up here. I'm unfettered by technological competence, so you don't have to worry about any slides from me. Well, let me get my watch out. So, first of all, I feel it's like those things where you have to congratulate the chair at the UNCITRAL working group meeting, so I'll do the reflexive. Thank you for inviting us, Ted, to the conference.
Thank you for coming.
And I will say this. So this is what happens in 7 years of academics. Before, when I was an untenured professor and came here, I produced this paper here with 130 footnotes. And you guys probably can't see the font, but this is what junior academics have to do in this country. This page here has 4 lines of text and 28 lines of footnote text. Okay? 7 years later, I turned in this paper with 6 footnotes, one of which is a Harry Potter joke, and a couple ideas. When I got bored of finding cases, I'll cite that case. That's what you do in the academic universe. So, in the spirit of academics, I did a normative paper called Beyond Carve-Outs, and I come up with an idea or a suggestion of a normative framework that can guide us in moving on to the next stage of international reform, because I think we are kind of at a I don't know what the right metaphor is, a crossroads here, or probably an inflection point, where we might be able to confront some of these choice of law issues that we weren't able to talk about seriously 7 years ago. And I think Jenny did a good job about talking about this sort of very inchoate, iterative process. For those of you into jurisprudence, it's I would pretentiously describe it as Habermasian. And once you reach that certain critical intellectual moment, then you're ready to start doing movement. And I think we might be there. And the problem is that Reet rightly points out that there's a recursion effect, because we don't know when we're there until we know what the change is, because the less the change is, the closer we are to being there. But sometimes you just have to throw it up against the wall and see if it goes forward, right? Subject to the bandwidth of not making Jenny explode with too many work projects. So what you do is you say something that sounds really narrow, like, oh, no, we're not going to do anything big. We'll just do enforcement and recognition of judgments, because that's not a choice of law issue at all, right? That's just a small little narrow thing, and then you stuff it in under that way. So I suggested in the paper what I call a third-order normative theory. So on choice of law. So if you say that the grand debate's been done already between universalism and territorialism, I call it a first-order debate, that we think ideally, purely, universalism for transactional gain, rough wash, etc., has much to commend itself. Okay. Now we live in the real world, and that's not going to happen right now, if anytime soon. So then we get modified universalism, which I call a second-order normative theory, that how is the best thing to do with reality today? And I think that that's gone along pretty well so far. Of course, it can be distorted. Of course, as Don rightly points out, if you start to get some backlash and retrenchment, the flexibility that's intrinsic in the system can come up and bite you, right? But that's a necessary part of having a flexible system. And I don't think if you didn't have the flexibility, it never would have got off the ground in the first place. And we're right to take caution of his notes, because if we get too greedy and too aggressive at specifying universalism before the parties are ready to digest it, as Christoph tells us, we'll just get backlash, and states will start exercising the public policy exception, and then the whole enterprise dies. But if we can move along this incremental path, which is what I suggested is plausible, and I think we are at a point where we can do that, then I want to suggest a third-order normative theory, which is how do you move from point A to point B within the modified universalist paradigm? And the extant regime we have right now is a presumption of lex fori concursus, right, with carve-outs, with exceptions, to say, okay, let's start with lex fori, but then we're going to carve out things for set-off, and we're going to carve out things for labor claims, and we're going to carve out things for avoidance actions, right? And so you have what I call a categorical exception-based approach. The second thing I want to say about the carve-out-based approach is we have to recognize honestly that that's what secondary proceedings are, in my opinion. Right? Secondary proceedings are a choice of law carve-out, namely for the secondary proceedings laws. It's a carve-out writ large. Every type of law is carved out if we have a secondary proceeding. So I consider the secondary proceeding to be an intellectual cognate of a carve-out. It is a carve-out from the lex fori concursus. So the third level question of normativity is, how do we decide what and which carve-outs we need, we can retire, have to be in there, have to not be in there? We can carve out whatever we want to, right? We can just flip a coin and say every time it lands heads, we're going to carve out from lex fori concursus. That's not a particularly intellectually compelling way of carving out law, but it certainly has a bright line clarity to it. Okay? So what I'm suggesting is that we should come up with some sort of normative theory that gives us an input as to whether carve-out A or B is desirable. But I'm also pragmatic, or flatter myself pragmatic enough, to recognize that that has to be done in the context of a real world of pragmatism, which has Unsatral with lots of people with divergent interests and stuff like that. So I want to start with the pure theory, and then we'll relax that idealistic assumption. And I must say, the beauty of international insolvency law as it's developed over the past decades is that it succeeds in this globalization force in spite of itself, right? It should theoretically be impossible to have this amount of agreement, and yet it just does. I think partly because of the opacity, because we don't get too clear into what the rules are, and it just sort of ad hoc European bumbles along, and then you have cooperation and happy cases that are coming up. So, rather than the categorical approach, I suggest we should try to cull a normative theory. And what I did was sort of cheat, which is I took my normative theory from the descriptive, which is inherently recursive, but that's fine, and say, well, let's look at what we should do. What are we doing? And can we find common themes in it? And there, when I go through the great exhaustive and exhausting reporter notes to the Global Principles Annex on choice of law, I think that there is a strong theme of reliance. That a lot of the carve-outs from local state law can be justified, some more comfortably, some with a little bit of fudging, through an ideal or a norm of reliance, which is protecting party reliance on the expectation that local law and not Comey law will govern a specific transaction with the debtor. Now, I try to refine that a bit in the paper. And so I say it's not just reliance writ large. The specific reliance that I would like to privilege is defensive party reliance on the application of local law. So in that I have three components, right? I have defensive, I have party, and I have reliance. And so I'd like to just unpack some of those concepts and tell you what my thinking on them is to see if that can help flesh out or constitute a viable theory. Let's start with party reliance. So I am interested in the reliance of the actual litigants or actors in a given transaction. I am less interested, and to the lamentation probably of choice of law scholars, with the public policy interests of the respective states. I'm not interested in protecting France's reliance. I'm interested in protecting a lender's reliance. Why? Because I think that there is sufficient outlet for the state reliance already with such mechanisms as the public policy escape clause. And so I think when we're entrenching onto public policies that are worrisome to the states, that's their outlet, not in the ex ante choice of law rule, is how I like to keep it. So in a way, I'm actually eschewing the context-based analysis upon which the modern conflicts and choice of law rules are premised. I don't think I'm going back fully to a vested rights kind of approach, but I do want the focus for this limited purpose, which is for choice of law carve-out in cross-border insolvency proceedings, to look at actual parties who are hurt by the reliance or who have invoked reliance. Okay. The second aspect of this is defensive reliance. And so I think something that should be familiar to lots of us in the common law legal system is the metaphor that's used between when law is used as a sword and when law is used as a shield. And I recognize that an economist would beat me with sticks for suggesting that that's a meaningful distinction, because to an economist, a loss is just is equal to a gain that was missed, right? There's no difference between positive and negative. But I do think that the law treats differently losing something versus the foregone opportunity to gain something. And so I think whether it is economically justifiable or not, I do think that there is an intuitive, normative, legal difference to say, I am a defendant and I thought I had a defense under local law and I relied on that defense under local law. Right? There's something, I think you can say it's a salience bias or a vividness bias, but I think there's something different when you have to write a check as the defendant in an avoidance action that you have to give back to the bankruptcy estate. So what I would like to do is hierarchically privilege defendant reliance, defensive reliance, over what I would consider offensive reliance. Okay, you want an example in the common law? Estoppel doctrines. Estoppel doctrines clearly privilege defensive postures over offensive postures. And we can get into the nitty-gritty of non-mutual collateral estoppel. I'll explain that to you over beer later. Okay, so I want to protect defensive reliance, I want to protect party reliance, and then I want to explain what it is that reliance is. I mentioned a salience bias or a vividness bias, which is that if you talk about the reliance of the parties, there is a temptation to focus on a specific party. So in the paper I talk about, say, an avoidance action. And you say, I'm going to go after A for an avoidance and give that money back to the bankruptcy estate. And A says, oh my God, I had no idea I committed avoidable preference. Under my local law, which my choice of law regime says applies, I have an absolute defense. And I relied on that defense. Okay? Protect my expectation. And that's fine. I agree with that proposition. The problem is, and I find this insufficiently recognized in the current international instruments we have, is if I was representing B through Z, the other creditors, I would just make the exact same argument. I would say, well, my goodness, he received a preference under our bankruptcy law, and we have an expectation that the estate will not be depleted by those assets, and so protect our reliance, please, by giving those assets back to their estate that we expected for distribution. And we never talk about their reliance in these. Why? Part of it is a salience bias because, as I said, you have concentrated losses versus diffuse gains, and the idea the guy losing the lawsuit is worse than is more imprinted on our minds than the marginal uptick in benefits we get from all being part of a preference versus being distributed around. But I do think there is something to the defense of reliance that I'm willing to intellectually justify what does seem like a cognitive bias, because I think it does smart more for the individual party who has relied on the defense under local law. So, how do we roll out a choice of law regime based on defensive party reliance in a carve-out based approach? Well, the most analytically pure way, so let's start with the Platonic ideal, would be to say when a party reasonably and actually relies upon the non-application of Comey law, relies upon the application of the law of X in structuring a transaction, then that law of X and not the Comey insolvency law will apply to a proceeding, okay, to an avoidance action or set-off. So if you relied on set-off in arranging your escrow account in Oklahoma, and it was reasonable to do so, then when there's a choice of law fight, you can plead actual reliance and you can be protected thus. I want to, having now articulated the Platonic ideal of how a reliance-based choice of law regime would work, I want to completely disavow it, because I want to stay part of the modified universalist regime, and I don't want to reinvent the wheel for the sake of academic purity. I have my tenure, so I don't have to come up with cute little theories anymore, and I can talk more sensibly. So what I would like to do is incrementally build upon the great work that's out there already. We do have these carve-outs out there, so what I want to do is use this framework to look at the carve-outs, see which ones are working and which ones are not working, and I want to do little refinements and tweaks along the edges. Let me give you an example. In the set-off approach that's done in the Global Principles Annex, they canvass, the reporters look at different ways they could do set-off. They say, well, we could allow a set-off if it's allowed under the laws of either jurisdiction. If the Comey or the local allows a set-off, then we allow the set-off. Or we can say, no, it's got to be allowed under both jurisdictions to get you to a set-off, okay? So you could have either one of those approaches, but it depends on what your normative vision is. So if your normative vision is protecting party defensive reliance, then the set-off rule I should take, which leaves me in happy alignment with what the reporters did, is to say if the passive claim allows it, that is to say if the would-be defendant's law allows the set-off, then the set-off should be allowed. So I give normative high marks to that rule when I subject it to my normative analysis. I say, good, that's a good application of the normative approach I'm endorsing. I go a little bit further, which is if, as a modified universalist, what I would like to do is push that approach and require the actual reliance. Because it's talked about in the commentary. They say, well, in addition to saying the law allows this defense, the local law allows this defense, should the creditor have to show that he relied on this application of local law? And they don't put that into the recommendations. I say yes. I think if you want to get out of Comey law, the burden should be on you to get out of Comey law. I want as much Comey law as possible, thus aligning myself with the universalists. But if you've actually relied upon it, then I'm willing to give you a defensive out. How can we operationalize that with rules of rollout? You can create presumptions. You can say, my goodness, if you're an entity and you don't transact business outside of your own state, you're presumed to have relied upon local law only. Right? Just a little evidentiary thing, rebuttable presumption if you want. What I mean by that is small guys are presumed to be relying on small local law. By corollary, big guys who know how the system works should be presumed to be relying on foreign state law. And the idea of being shocked to learn that Toyota is a Japanese company rings hollow to me when you're a large investment bank, working around the rules. So basically what I'm doing is I call this in the paper calling the reliance bluff. Because I think that when people say, well, we need to rely on the defenses we have under local law, sometimes that's true, but sometimes it's just naked exploitation and arbitrage of people who get a favorable distribution under local law and they say, well, we have to be protected by the local law that we relied upon that gives us more money under this circumstance. So that's why I would like to call the reliance bluff. I want to keep it out there, protect it when it's actually warranted, and take it away from the people who are just using it, what I'll call greedily. Now, let's look at another choice of law, lex laboris, if I'm pronouncing that properly. The labor law, right, being governed by the law of the labor contract. Completely impossible to reconcile with expectations. Let's be honest. First of all, I just think as an epistemological matter or whatever, I don't think the average worker has any idea what his or her insolvency payoff entitlements are under law. I use in my paper a sample size of 1, which is I had no idea what the bankruptcy priority rules for wages were until I became a bankruptcy professor, and I worked at many jobs prior to that. So I think it's difficult to rationalize that there's expectations involved there. And in the legislative guide, they're quite candid about it. They say, well, the purpose of the carve-out is to protect jobs and local employees, which is a commendable goal, right? It's a pro-labor goal, and I'm fine with that. But that's not an expectations-based analysis. If you were being firm to an expectations-based analysis, you should say, well, we take the local law, whether it's protective of jobs or whether it's destructive of jobs. Right? They say, well, we don't want to discriminate. We don't want local workers to be discriminated based on their work for a domestic or a foreign proceeding. Well, my goodness, my conjecture is that if a local worker does better under the application of a foreign insolvency laws, Comey laws, for how much money they'll get in a bankruptcy, they will be happily discriminated against and take that application of foreign law in a heartbeat. Okay? So, under the normative framework, I have to flunk lex laboris. Now, this is where I get back to the reality world and Christoph's world. I'm still okay with it. And I don't think it's an intellectual cop-out, or I don't think it is normatively vacuous for me to suggest that we should have a presumptive normative rule of defensive reliance, and yet nevertheless allow certain highly sensitive policy overrides. I don't think that's gibberish. I think you can say we try to have only defensive reliance, but there are some super touchy issues we're just going to leave off the table. And I'm okay with that. And you say it's for limited policy areas. It's too sensitive. I'll use Hannah's idea. It engages too much public law, too much public policy, like the termination of employee rights, etc. And so lex laboris I justify under that thing, and so I can keep that and keep it within my modified universalist framework. Now, 10 years ago, 15 years ago, I would have put tax claims in that as well. I would have said, well, tax claims, they're so public, probably no way you're going to get those. And now look at tax priorities, right? They're being abolished left, right, and center. So I think, when we come back in the next 7 years from now, Ted, maybe labor will no longer be this sensitive, but this is where it is right now. So I would keep the carve-out justified under a policy exception and not freak out states who are thinking about whether to subscribe to the next modified universalist regime. I think it's just too touchy an issue. And the last thing I would carve out would be just historical path dependency. Like the situs, whatever rule for real property is pretty well entrenched. I don't want to fight that for Comey purposes. Just say it's fine. Everyone knows what that is already. I see application of this rule of reliance, particularly in instances where, I said like the average worker is not going to know what his or her priority claim is. I think by contrast, the average director or officer is keenly aware of what his or her legal defenses are, and I would feel uncomfortable subjecting them to corporate liability under a Comey state's law, because I think that's likely that they actually did rely on the defensive counsel telling them that this is what you're allowed to do under your local regime. So that would be an example of a defensive carve-out that I would permit. Thus, in conclusion, I think I am friendly, or at least a cousin, to Ted's proposal I do come up from a universalist standpoint and say it should be presumptively lex fora concursus unless there's a justified carve-out. The carve-out should be based on defensive reliance only, subject to maybe historically strongly entrenched tradition and super delicate policy areas that we don't want to touch for now, and we can fight another fight later on. And what that means, Ted, is because I still allow for these carve-outs, I still have to allow for the situation and location of assets, because some of the stuff will be carved out, which means I'm all on board with your identification of the claims and assets exercise. I think we have to identify both the location of assets and the Comeys. And I think I will conclude thus.
Before we take questions, I just want to give the panelists a chance for replies, rebuttals, or retribution for remarks by the fellow panelists.
I have something. I have some notes I made. I wanted to, Ted. I was just thinking about. Sorry. I was thinking about the corporate form and how we can respect the corporate form and not damage it too much. With subcon and stuff like that. And it strikes me that, if I talked about this morning, if we have a strong system of registered interest and security interest and stuff like that, to the extent that you're relying on corporate forms for financing, does a well-respected registration, perfection, whatever you want to call it, system for security, does that sort of cover most of the ground so it's not a problem?
So I was actually your question for me mirrored a question that I was going to ask myself. So this is.
I'm happy to be your
no,
interlocutor.
No, I couldn't figure out how to ask myself, so I'm glad you asked it. I think the answer is no, but I'm troubled by that, and let me explain why. Which is one of the things that gives me some heartburn when I start talking about these respect of the corporate form, respect of the territorial distribution, and so on, is it reminds me of debates elsewhere in bankruptcy where I'm on exactly the opposite side, which is large sophisticated creditors in bankruptcy cases seek in many, many complicated ways to engage in asset partitioning. And securitization, the corporate form, allocation of assets between and around within the corporate form. And one of the things that as domestic bankruptcy lawyers we resist is the opportunistic partitioning of assets in order to, how should I say it, screw people. Mm-hmm. And what I've just created in this regime is a presumptive respect of asset partitioning, and I've layered on a geographic asset partition on top of the corporate asset partition. Okay, so why am I doing this, right? I mean, why am I taking us down this road? And so this is your question, right? And the answer is twofold. One, I think that a domestic bankruptcy architecture needs to be able to respond to these opportunisms within the national structure. But as a pragmatic matter, I worry about the international architecture's ability to be a bulwark against those things. And so there is a point at which a question raised earlier today is the EU reg situation different from the UNCITRAL situation, different from the US situation, which is how much do we want to freight the international bankruptcy architecture with fighting facts on the ground that it may not be equipped to fight. And so to the extent that what I'm trying to do here is figure out a way to asset maximize, right, and to value maximize, I'm willing at the international level to accept a greater level of asset partitioning than I would at the domestic level, and hope that that gets dealt with domestically, because the local courts are in a better position to deal with that, and to allow them, here's the other part, to allow them to deal with it domestically, you have to have a robust choice of law regime in order to prevent forum shopping. Okay, that's.
You know, I'm just a simple guy from Manhattan.
Yeah. I sorry. I'm from Westchester. I mean, they were complicated up there.
Or even better, Oklahoma. I think we've heard two brilliant discussions of the issues of asset partitioning, asset maximization, normative rules, international architecture, all of which I think is fine, but I do come back to the words of the statute, as the Supreme Court tells me I must. And I think it can be argued that Comonda got Article 22(1) wrong when they looked at the interests of the American creditors alone. But that's a construction that we may be stuck with in the United States for a long time. And maybe there's something that the guide or the legislative guide can help to correct, but we may be stuck with it. But we're certainly stuck with Article 21(2), which says that the court, after recognition of a foreign proceeding, may entrust the distribution of all or part of the debtor's assets located in this state to the foreign representative or another person designated by the court, provided that the court is satisfied that the interests of creditors in this state are adequately protected. So all I can say is that you're not going to get the assets in this state unless the creditors here are adequately protected. It's just not going to happen. And the statute says it's not going to happen. So you have to determine what that means, and it may mean exactly the limited definition that you suggest. But I think a limited definition is going to be difficult for a court to adhere to. And if you want the assets or the value distributed to the main proceeding, and I endorse that wholeheartedly, the creditors in the local state have got to be sufficiently protected under the U.S. formulation, or adequately protected, whether they relied or they didn't rely. I think that's the law that we're dealing with. I don't think it's such a bad law, by the way. I'm not criticizing the law in any way, but it is the law we have to administer. I think virtual territoriality, in your words, Tim, or Gabriel's words, synthetic proceedings, I think they work very well alongside this particular language. I've looked at the specific language of our Chapter 15. You could even, I think, argue that there's enough room in Chapter 15 to recognize foreign priorities if you get funds distributed to the United States, for example, for distribution here. Jay has spoken about using the idea of choice of law, that somehow the assets that you get for distribution here, in that example, would be imbued with the distributional attributes of the foreign nation. There are a number of different theories that I think you might be able to use. Certainly in this country, we routinely pay all foreign creditors at the outset of a case in order to protect the assets of the estate. And that's even contemplated, I think, by Section 363. That's for another day. But I think we have to bring this back to the statute as it's written.
Chuck, you look like you want to toss in a few words.
I understood John's project to be figure out what was a normatively sound choice of law rule in the secondary and defensive reliance on non-Comey law.
Yes.
But I'm not sure how I can defensively rely on non-Comey law unless I know the secondary is choice of law rule. And of course, that's what we're trying to figure out. And Ted seems to assume that the choice of law already is harmonized because every state is going to apply territorially its distributional rules. So we've got harmonization under that approach. But my really interest is with Judge Gropper when you say, look at the choice of law first. And if that tells you Oklahoma, well, that may be the end of the discussion. But if that tells you Germany, you still have to go through the 21 and 22 analysis on top of that, right?
Well, I think what I'm trying to
And
say is
seven
that I
and
think
five.
the Article 21 and 22 analysis is better informed by a choice of law analysis or a conflict of law analysis than it is by the often prejudicial question, is it them versus us?
Can I respond briefly? Sure. Yeah, I think that I agree. We brought this up too. There's a sort of an intrinsic recursion to what your expectations are, because if your expectations is within a universalist system, then you should have the expectation of foreign law. I think what I'm trying to capture is the idea of a truly local creditor who does not transact a lot of international business, who has a lending relationship with a multinational that might have its headquarters abroad, but has a local affiliate, operating affiliate that it has only done business with. And so there, I would be willing to presume an expectation that the domestic law would apply and give those guys, that is to say, the truly local creditors, a defense to the foreign state Comey law. That's my thing.
Incentive to be ignorant.
Exactly. I'm trying to. It's called a stupidity subsidy. It's a great framing for what I'm doing.
So I'm not for the purposes of my example, I did assume harmonized choice of law rules. For the purposes of the normative project, one doesn't need harmonized choice of law rules. It's just would have been harder for me to do it in 20 minutes. So I think it's still you still have the recursion happens whether or not the rules are harmonized. One of the things that Judge Gropper said that I wanted to, I think your point was this is all great, but you're never going to be able to actually limit secured credit to that liquidation value that you just said that you would be able to use. I was just reading Fisker's, and I thought, wait, maybe I'm right. I would have agreed with you until like the day before yesterday when I saw a court going in that direction.
I'm not. That's it certainly is an argument that you should, in terms of valuing collateral, you should use a liquidation value versus a reorganization value. And it's certainly been argued that you should capture the reorganization value for the benefit of the estate, not for the benefit of the secured creditor.
Right, and the limit of what I'm saying is that when we're talking about sufficient protection and expectations, that I don't know if it's a liquidation value or a non-liquidation value, a territorially realizable value is practically the value that's going to be playing in the negotiation, and therefore is probably the right one to sort of use to give meaning to that text.
Or even subject to a discount. You can say like there's a litigation fighting discount below the liquidation value, right?
Yeah.
Let's see if we can get in some questions from non-speakers now. Hannah.
I think this is a question for John, and so I'm not worried as much about the ignorant subsidy end of your model as the manipulable end of your model. And so I'm wondering, do you see at all a role for contract as a means of setting that reasonable reliance? Because if so, and I don't, as you know, I don't mean that in the private contract the parties could choose the insolvency law, but that they could use contract to situate the contract
Exploitation. Yeah, so my punt in the paper is I agree. If I'm going to take a reliance-based approach, then I have to embrace contractualism because that's literally the explicit reliance of the parties to the contract. So can I embrace contractualism and still police the manipulation and exploitation? And I think you can. I think you can, because I do believe that. How about this? Let's start from a libertarian or small L liberal autonomy position, which is that contract is presumptively fine unless it's being abused. What's the abuse in bankruptcy? They're multi-party proceedings, so you're worried about the contracting parties picking something that screws absent third parties. Okay? So what you do to police that is you can try approaches like saying, well, there has to be some connection to the forum law. I think even that's manipulable. And so I would suggest that a rule like this, just drafting off the top of my head, is that the choice of law pursuant to contract is presumptively validated unless it can be demonstrated that there are adverse third-party effects, in which case the parties don't get. So I would see the contract as presumptive but not dispositive. CF family law, where people have child custody agreements, they can put that in, but it's not dispositive because the third party the court considers the best interest of the child.
What would it sounds like party autonomy except when it makes a difference.
Yeah, but
Or party autonomy, except when the various forms of interest that we now worry about under the heading of
Right. I mean, economists would say negative externalities, right? If there's negative externalities.
Just got a few more in. Susan, I think you were next.
So I find the difference between Ted and John's paper interesting because it almost sounds like the difference between the expectation measure of damages and the reliance measure of damages. But I'm wondering why the reliance measure of damages, that is John's perfect proposal, would ever protect non-adjusting creditors. And so you pick on tax claims, which are a type of non-adjusting creditor, and say you're willing to give because of the political sensitivities. But is there any end to that? Because I'll just make it politically sensitive.
No, I'm saying the other way around, which is that we've already left tax claims behind, and I don't want to lift that carpet again.
Are you a German resident? In the United States, they're pretty high.
I'm sorry. I'm speaking to the current proposals like the Global Principles Annex, and so I'm unlike what Judge Gropper's doing. I'm talking about like what's going to guide us in the future direction.
Oh, and I guess I'm like Judge Gropper and thinking about how U.S. judges are going to construe this stuff, right? So yeah, so we have to.
Are you worried they're going to use like 1506, even though there's not a carve-out for tax? They say, well, it just violates our public policy to pay a foreign tax party?
Well, no,
Are we negotiating what the question is now? So maybe we can take that negotiation offline.
Yes, exactly.
Okay. John.
Well, let's maybe start out with points that we've just been discussing, because the problem I have with a reliance solution or a contractual solution is it sounds very case by case. And I can see looking at our insolvency law from a larger perspective and saying these categories of creditors are likely to have relied, so these categories are going to get priority, these categories are not likely to have relied, so they won't get it. We're not going to look at their contracts, we're not going to look at their, unless we say all contracting creditors who are in the territory and the contract was signed by the local company. It just seems to me we have to deal with categories. Mm-hmm. We have to have rules that are easily administered, because this process, which is a collective process, can very easily break down if we have to make the distinctions too many times.
Yeah, I consider that a friendly amendment, because what we can do is we can create those categories normatively anchored by reliance. Say these guys are likely to rely, these guys are not, and so I talk about presumed reliance. I'm okay with that.
Right. Okay. On Ted's issues, I have two questions. One, which I think I know the answer to, is whether you're looking at your secondary proceeding, this hypothetical secondary proceeding, on a purely value basis, so that, for example, if in the local jurisdiction a secured creditor can pick up its assets and go home, that's not really what you're saying. You're saying, what would their recovery have been if they did that? And if we have a system in the main proceeding where we're going to reorganize the company and we have a stay and they can't pick up their marbles and go home. Well, they're stayed, and we're only going to give them the value of what they would have gotten.
Yeah, what you said.
Okay. Yeah. All right. So, and then that raises the question, what happens if the main proceeding is in a country that does liquidations and the foreign law, the non-main proceedings, are reorganization country? So you have to, your hypothetical case is a reorganization.
In other words, you could have achieved a higher value if you could have reorganized. Let me make sure.
Yes, so, in the main proceeding, we just liquidate. We don't preserve going concern value. We're going to liquidate the local operation just as well as the main country operation, and everyone's getting 20 cents on the dollar. And the creditor in the local country says, well, we would have reorganized here, and frankly, I would have gotten 40 cents on the dollar.
Yeah, actually, that's so. No, actually, I do know the answer to that question. Okay. Or at least I know the answer that my perfect regime would yield in that situation, because it comes the metaphor that I have operating in my head is you don't get to do a Chapter 11 case in the U.S. unless you satisfy Pareto optimality. Remember, I said we were in that my concern about universalism and modified universalism is it turns on a Kaldor-Hicks efficiency rationale, and what I'm going for here is a baseline Pareto optimal result. That's the economic point rather than the legal point. So to get to Chapter 11 and do a reorganization or a going concern sale, you have to satisfy best interests. You have to clear the hurdle. If you can't, you don't get to do it, right? And so what I'm suggesting here is that the price of central administration is that you be able to say, I don't care what your procedure is in the main, but if you want to basically bind the secondary, you have to be able to say, we are getting you at least as much as you would get. Now, if
in a liquidation,
in whatever it is you do,
okay,
in whatever it is that you do, and so here's why it's an okay result, right? So if your main that only liquidates and yields sub-efficient values, right, says we're going to do it and you're stayed, and you say, well, look, I'd get 40 instead of 20, the answer should be, right, either I get to walk away, or if you really care about central administration, you got to buy me off.
I have a quick amendment to that, which Judge Gropper will like because it's real law. And that is that, remember, secondaries are territorially limited. So even if you have reorganization under your secondary law, you can only reorganize those assets within your physical.
Well, I'm thinking of it in the context of corporate groups if we were to apply the same
You're
principle.
assuming you're assuming that whatever the division or group was in jurisdiction A could be reorganized at a higher value.
Independently.
Yeah, no, I think the best interest, it's a best interest point, and the point is that what we're basically saying is that central administration is, it's not a Chapter 11, it's a Chapter 11.5, which is we're going to do it and we're going to do it globally, but you only get to do it globally if you can satisfy that best interest hurdle.
Well, we have about 3 minutes left, and so I'm going to exercise the time-honored prerogative of the chair to ask a question that can't possibly be answered in 3 minutes, and maybe even can't be asked in 3 minutes. And that is when I came in a bit late this morning, and I ran into one of my colleagues who had to leave early, and I asked him how the symposium was going. And then this colleague is someone who's a nationally known authority on choice of law. He's not an innocent. And he said to me, it's very interesting because everything they're talking about, I don't know, and everything I know, they're not talking about. And I thought that was a very interesting observation because as we all listen to this, it's very heavy on insolvency policy and very light on conflict of laws theory. And to me, that's a pretty interesting point. I think it may relate to what Chuck said a few minutes ago, which is we're sort of making an assumption here that we're all basically in agreement. We have basically the same rules and basically the same conflict of laws ideas, and we're really only talking about nuance. And what if they're really different? Because after all, if we're sharing policies, we don't have the conflict that conflict of laws resolve. So why are we so heavy on insolvency and so light on choice of law in a choice of law symposium? My colleague would ask.
Well, one reason I would suggest is that the choice of law professors, and it is very professorially directed, have never really grappled with the insolvency issues. I scoured the Restatement of Conflicts, which is our sort of Bible of what our conflicts of law would say. Not a thing, nothing, or almost nothing. So where I would start is, and I think it could accommodate both of the professors to my right, I would start with taking the global principles and translating them into something that a judge in the United States would understand through the analysis in something like the restatement. Now, I think our professor of conflicts law is going to say I'm either wrong or only partially right.
I would never say such thing.
No, you can. No.
Anyway,
No.
as Neil said, we're already. So let me just say, I think that another place you would need to look would be not at the Restatement of Conflicts, but at the Restatement of Foreign Relations Law of the United States.
I did.
Right, which is, and this is the weirdness of insolvency law, that it is at this interface between what we in the U.S. would think of as regulatory law, and therefore situated bizarrely to our foreign counterparts in the Restatement of Foreign Relations, and private law. And so, yeah, I mean, I certainly agree with the basic point, which is that choice of law scholars as a group have not swamped insolvency.
Yeah,
Maybe we should start.
You now know why I said to Aaron, please come to our conference, and why I said to Hannah, please come to our conference, because I know how little I know about actual choice of law principles.
This is the known unknown, as our former secretary.
Yes, this is the known unknown.
Now there's only one thing standing between us and a break. Actually, two things standing between us and a break. First is Bob's question.
Yeah, just trying to explain. Ian Fletcher from London and I were the reporters for the American Law Institute III report on, I think the word is transnational, whatever. So you have principles, you have guidelines, and we have rules. The principles and the guidelines were, for instance, accepted by III. The first day we started to talk about what we call the global rules, about 22 or 24, Ted was there, Jay was there, some others, Chuck was there. After 10 minutes, it was a row. There was no agreement at all. Is this the topic, and what are the angles of the topic? And we were, is the word flabbergasted or surprised? Because in Europe, it's already there 10 or 15 years. So we presented as a personal gift to the global audience the global rules. And my dear friend Chuck takes them much too serious in his paper, asking why is this and that and that. We are not defending it. It is a start for a discussion. But please refer to them not as global principles, but as being the global rules. And you can find them on www.iiiglobal.org.
Yeah,
there they are.
They're in the book.
They're in the book, and they're on our website, too.
Okay,
so.
I'm sorry.
And now there's only one thing standing between us and a break, and that is to congratulate our panelists on the wonderful job.